pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Everyone who needs to be sworn in, please remain standing. And Sherry, if you would swear those folks in, please.
Anyone that's going to speak, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth so help you God? Thank you.
Great. Thank you very much. Last month's minutes. Does anybody have any deletions or additions to those minutes?
Move to adopt as presented.
I second that. All in favor?
Aye.
Aye.
All opposed? Hearing none. Motion carries. Staff, any additions or deletions to the agenda today?
I have one deletion, which would fall under Section 4C 1H to Tony Properties.
1H. Okay.
It's complied, and he's paid for a citation.
Thank you. Officer Sanderson?
Under request for a board order, item C, subsection F, case 15CE5731, violator Paul Price and Judith War is being pulled because the property is in compliance.
Thank you.
Same section, subsection K, case 15CE5805, violator John Zudans and Tracy Lockwood. It's being pulled because the permitting process through the planning department is in place.
Thank you. Ms. Hunter?
Hi.
Hi.
Betty Hunter with the building department. They have not applied for a permit through the building department yet.
Who is not?
The one that's getting
John Valdez?
Zudans.
Oh, Zudan?
Mm-hmm. Yeah, Summerlin's their contractor, and they have not been in to apply for a building permit.
Officer Sanderson?
Application was submitted Friday to the planning department. It's under review by us, and I understand once we review it, then it goes to building department. Some people start with the building department, and then it's routed to us, and sometimes it goes through us for our code compliance certification and then goes their way.
Would you like to wait until next month to see where it stands? Pull it for this meeting?
Yes, sir.
Sure. Okay. Any other changes?
Yes, sir. I have one change. I'd like to pull Citation Appeal 4AC, Frank Loya Jr. That citation has been paid.
4AC. Thank you. Any other changes?
Oh.
Yes, ma'am. That's fine.
Yeah, and we'll pull.
We're getting shorter and shorter on the
yes.
meeting now. I'm okay with that.
Yeah. Citation Appeals A, D, violator Stephen B. Thurn, case number 15-CE 5921. That was paid also.
Okay. Great.
Making progress.
That's right. Send him a thank you note. Any other changes?
Move to adopt as amended.
I second it.
Y'all still trying to decide, Ms. Hunter?
No,
are y'all finished?
we're
Okay.
good.
All in favor?
Aye.
All opposed? Hearing none, motion carries. Okay, we're going to continue on to evidentiary hearings. Citation appeals, case number 15-CE-5519, Timothy McNamee. Yes, sir.
And Mr. Chairman,
Yes,
if I could, I'd like to introduce, if you haven't met him, John Kesnick. He's from
Kesnick.
Mr. Frost's office, and the city has retained him along with out of Mr. Frost's office for prosecution of some of these code enforcement cases.
Repeat that last name again, please.
It's Kesnick.
Kesnick?
Yes, sir.
Thank you.
Thank you for having me.
Thank you for coming. Mr. McNamee, were you sworn in?
Yes, I was.
Great. State your name and address for the record, please.
Timothy McNamee, 1350 Indian Mound Trail in Castaway Cove, Vero Beach, Florida, 32963.
Thank you, sir. We're going to give the staff an opportunity to speak first. If you'd like to continue, that'd be fine.
That'd be Mr. Kesnick.
Oh, does he need to go first?
He's the prosecutor.
I see. Let's go ahead.
Okay.
Yes, sir.
John, in the drawer there's a microphone. If you could use that, it'll get on the record. Just have to turn it on.
Yeah, sure.
By the way,
Yeah, you'll just need to turn it on. You're putting that on the dot cam?
Yes.
let me mention something while I'm thinking about it. If everybody would do me a favor and just make sure their phones are turned off. I appreciate it.
If I can start from asking questions of Mr. Ramsey.
Sure.
Mr. Ramsey, did you have a chance to investigate the property in question?
Yes, I did.
How did you become aware of this property being a possible violation of city ordinances?
For an internet search of vacation rentals by owner.
How did you, what did your internet search pull up?
It found his home property was advertising for less than 30-day rentals.
And how did you follow up on that initial indication of a possible violation?
With a warning citation 0508T, which I mailed certified return receipt requested.
And did you post that sort of citation on the residence?
I did.
Did you take a photograph of that?
I did.
How did your investigation continue from there?
At that point, I received a call from Mr. McNamee. He was upset about the posting and the fact that he would not be able to keep previously arranged rentals. He agreed to come into the planning office and meet with myself and Director McGarry. On 3/12/15, I met with Mr. McNamee and his son in my office. He stated he would change his advertising, which he has. He had 5 to 7 reservations that he would like to keep. I asked him to provide me with these dates, and I would speak to my boss. On 3/16/15, I received an email correspondence from Mr. McNamee, again stating his disagreement with the short-term rental codes and policies. He did supply 6 different blocks of times that he had rented his home out before I had cited him.
Were any of these blocks of times greater than 30 days?
No, they were not.
So these are blocks of times ranging from, I guess, a week to a couple weeks?
Correct.
Okay. What happened from there?
I responded. I spoke to the management. In my case, at that time, it was Mr. McGarry, and was informed that unfortunately the city would not be offering any grandfathering or honoring any previous commitments. I informed him of that via an email.
How did you continue your investigation?
I just continued to monitor the property off and on. From 3/18 through 6/28, there was no activity that I found. On 6/29, I found multiple vehicles there with tags, which I ultimately ended up running. I received the name of the persons that were renting. I made contact with them, and they indicated to me that they were, in fact, renting for a week. I, at that time, issued a citation with penalty to Mr. McNamee.
Did you post that citation?
I did.
Did you take a photograph of that?
I did.
I don't have any further questions. May I present evidence this time?
Sure. And we'll need to retain a copy of any evidence you present, as you probably know.
Copies for everybody. Thank
Great,
you.
thanks.
Mr. Ramsey, is this the internet
Can you-
advertisement that you...
Can you speak into the microphone,
Oh, I
please?
apologize. Is this on?
Right. Give it a shot.
Hello, testing.
That thing's finicky.
There you go.
That's good.
Mr. Ramsey, is this a copy of the advertisement that you located that began your investigation?
Yes, it is.
And did this advertisement indicate weekly rentals?
Yes, it did. Well, nightly rentals with a minimum stay of 4 to 7 nights.
So there was a minimal period of 4 nights that was available for renting?
Correct.
Mr. Ramsey, can you see that?
Yes, I can.
Can you identify that, please?
That's the warning citation 0508T issued to Mr. McNamee.
Could you identify that photograph, Mr. Ramsey?
It's a photograph of said citation in front of the home at 1350 Indian Mound Trail.
Could you identify this document, Mr. Ramsey?
It's an affidavit of my posting and the mailing of the citation.
Is this a copy of the email correspondence that you had with Mr. McNamee?
It is, yes.
And are these the dates that he indicated he anticipated future rentals?
Yes, they are.
Can you identify that document, Mr. Ramsey?
This is a citation with penalty 0657T that I issued subsequent to finding renters at the property.
And those renters indicated to you that they were there for a short-term rental?
Correct.
Can you identify the photograph that's displayed currently?
This is citation 0657T posted on the property in front of the home.
I don't have any further questions. Thank you, Mr. Ramsey. That concludes my presentation.
Great. Thank you. This would be a good time for Mr. McNamee to speak if you'd like to say a few words.
And
Yes.
first, Mr. Chairman, if he has any questions for the officer, he should ask those now.
Well, let's, you talk about Mr. McNamee or Mr.?
Yes. Yeah.
Okay. Do you have any questions for the officer, Mr. McNamee?
Yes. One thing is
regarding testimony.
When I was issued the first, the warning on March, whatever that was, the warning was actually dated February 6th, but it was not issued till the first week of March. I'm not sure why it was a month delay on the top of that to when it was issued. I did indicate to Mr. Ramsey when I received that and went in with him and said that the renter I had in there was actually, even though my advertisement was for, I was attempting to do longer term. The person that was there was in there from January through March, Ms. Hughes. I showed him a copy of the lease and I said that she's still there and he's welcome to go speak with her or she would sign an affidavit to such. So she was not in there for less than 30 days. She was in there for that 3-month period of time. And I did show him proof of that. So that my contention then was that warning should have been rescinded because I was not in violation of any city codes at that time. I did also tell him at the time that, one, I've lived in Vero Beach for 20 years. I've had property in Castaway Cove for the past 16 years, and I've had this property for the last 3, and we lived in it for the first 2. I told him I was planning on moving back in there once we did some renovations. But I told him that before I put that property up for rent in season, that I had researched and, one, checked with my homeowners that there was no restrictions on short-term rentals, and there was not. And then the city, there was articles about city can't halt vacation rentals, city abandoned its fight on short-term rentals. I knew some of the story of going on with the Carrolls and their short-term rentals, so I was aware that that was not an issue currently, and that was not an issue at the time I was renting. The leases that I had, for which I freely gave him the information on, were all enacted before January of 2015. Many of those are actually people that were coming for visiting family, for graduations at St. Ed's and other and colleges here. And I said that I was told I had a legal obligation to honor those leases without canceling those. One, they were enacted in good faith when I was not in violation of anything. And 2, they were done prior to any changes of city code, for which we were not notified. Even the city code was changed without any public input from what I could see. In the warning letter, it says that if you have future rentals, please let them know to work out an arrangement, which is what I did. I was open and honest throughout the whole process for what I was doing. I live in Castaway. I have neighbors there. We've rehabbed 5 houses in Castaway over the last 4 years. So I have a vested interest in keeping the property values, keeping it nice, and maintaining it. I'm not an absentee owner. I screen my renters, and I have done a good job over the many years I've had long and short-term rentals. I find it disingenuous that I'm being now cited for something that I fully disclosed and I thought had a valid reason to do so. I also saw that they were granting the owners 90 days to be in compliance with rentals, to give them a chance for the leases they had in effect. I've heard back and forth as to that is true or not. But I want Mr. Ramsey to acknowledge that I did tell him this information and that the first warning was issued incorrectly, that that person was there for more than 30 days. Correct, Mr. Ramsey?
Correct.
Thank you. The other ones that were done were, like I said, I honestly disclosed who they were when they were. The citation that was issued was one that that person had rented, I think, a year before. The previous September, they booked that time frame. I don't know why I should penalize people that have plans, family arrangements, weddings, graduations, and upset them when I'm legally obligated to honor those leases. Unfortunately, in my leases, I did not have that I could unilaterally back out of a lease. They had the ability to cancel with notice. I did not have that ability. And I was given legal advice that I would be at jeopardy for doing so and could incur further penalties. So I don't see why that I'm the problem when I've been honest with that. I have since, as soon as I had that warning, I changed my ad to greater than 30 days. I didn't do any further rentals after that either, to be perfectly honest. I do have 2 people potentially for next season that are 2 months and 7 weeks each, so they're both greater than 30 days. And I've also listed the property for sale. So I acquiesce you win. I'm not going to win long-term doing short-term rentals, nor do I care to. But I am actively listed the property, and I've had one showing today and have another one this afternoon. So if I can sell the property, I will. But in the meantime, I think I've been open and honest, and I've tried to be in compliance with all of the schizophrenic regulations that have been coming through the city without any notification. Even from the time frame of the first warning to there was no follow-up as to what city regulations were changing, what the process was for trying to be in compliance. He's had my email, my phone number, and my address. And the only thing I've gotten is the warning and the citation notices. So I feel it's, unfair to penalize me and cite me a fine for something that I've tried to be in compliance with and have been in compliance with since the first warning, which was an incorrect warning, and I felt should have been rescinded. I was also under the assumption that was rescinding, that would invalidate the citation that was issued in June.
Officer Ramsey.
Any questions?
I have no questions. I have a few statements. Number one, the issuance of the code enforcement warning citation is a courtesy. It's not a requirement. We do that generally in every case, and we did so in your case, but it's not a requirement. So the need to rescind that, or the fact that I issue that and you feel that it's incorrect, really to me has no bearing on the citation itself. That would be my first statement. Once you were issued the citation with penalty, you continued to rent to the obligations that you already had for the reasons that you stated. Is that correct?
For that week, yes.
Okay.
Actually, at that point, I was out of the country, and that was actually my last rental, I believe, for the summer. One had canceled after that, so I did not have anyone there after that period of time, I believe.
Officer Ramsey, to clarify, was that the 29th that you were speaking of earlier?
Yes.
They rented from the 29th through the 1st, I don't know, the 4th or something like that.
Yes. Okay.
And lastly, I mean, just not that it really, I don't think, comes into play too much, but you had mentioned that you had approval from your homeowners association, whereas they were the ones who have been contacting me making the complaints.
No, I asked for approval. We do not have restrictions on short-term rentals in our homeowners associations. That has been confirmed.
Okay.
In writing?
It's on our homeowners docs. It is in writing. They are trying to change it, and I'm sure they will change it at the next annual meeting in December. They had a poll in maybe April, but they had very little response to whether there would be interest on the homeowners for changing the rental laws in there.
Right, and the bylaws of the HOA aren't germane to the situation, so.
Right, so with the HOA, you're asking the question. I'm just telling you the HOA does not have restrictions on short-term rentals in our community currently. And one of the reasons for selling the property is that I realize in the long term I'm not going to win that battle. I'm realistic enough to understand that.
nothing more.
Nothing more? Mr. Kesnick?
Yes, sir. Just a brief statement. As Officer Ramsey alluded to, Section 2.2-296 of the City Ordinance of Vero Beach indicates the warning is not a prerequisite in any sort of citation. So while I certainly understand the argument about any possible defects with it, it doesn't have any bearing on the citation. Furthermore, as you alluded to, that we're here in terms of a violation of city ordinances, so a homeowners association's bylaws wouldn't have any bearing on that matter. The purpose of the area that house is in, Zone 4, is specifically in the city ordinances, not for commercial use. The boarding or renting of a transient population is considered commercial use, and there's also in city ordinances any rental less than 30 days is per se a transient and commercial use. So I think that based on the evidence we have here, we've certainly met the low burden of preponderance of the evidence that is in violation of city ordinances. That's my thank you, sir.
Thank you.
Can I ask the question then?
Yes, sir.
Why were the articles that the city was abandoning the fight for short-term rentals in the fall publicized?
The city doesn't control the press and what they and what they publish. I'm sorry.
The lawsuits that failed, the Carrolls, that was not a legal issue?
That was that case. We're here on your case.
My point
it's no
is,
precedent to this case.
Well, my point was that when I entered into legal leases with future tenants with the assumption that I was not in any violation of any homeowners or city code that I was aware of, because I know you've since changed or modified the code after that, but I feel that's unfair to penalize me for that. And also in your warning citation, it says that if you have issues with future rentals, please contact the city, which is what I did and tried to arrange that, what the situation was. I've acted in good faith. I feel it's unfair to be penalized and fined for something that I've acted in good faith. I've made all the appropriate changes at the time frame I was requested to do so and haven't done anything more. I told Mr. Ramsey the other day, the house is empty. He's welcome to go there and view it at any time. I do not have any issues with that.
Okay. I believe you. I think you acted in the best faith
I just don't know what more I could have done to be in compliance and try to do things without harming innocent people. That I think was unfair.
You did. See, what I think you did is you acted in good faith right up until the point of having, quote, short-term rentals in the house on the 29th to the 4th or whatever it was. That said, that would have been in violation whether you were looking out for the best interest of the renter or not. And I think you did the right thing by telling Officer Ramsey what was going on and the fact that you had more renters and more obligations that were coming. And it's too bad that this was the case for you, but the city said, you know what, even though you have obligations, we're not going to allow those obligations to stand, and you had to make a decision.
But there was an article concerning that they were going to allow people with rentals a 90-day period to finalize before being in violation.
Did you check with the city?
I've seen 3 different articles on it. I've been out of town most of the summer, so to tell the truth, I don't know where it actually stands. I've heard different arguments from different people at different times. I know there was an article I saw where maybe 2 months ago, people entered into compliance agreements. So was that not done at that time?
Well, I've read a lot of articles as well, and I'm having trouble keeping up with what's really real.
But you're on the code. It says, I've gotten no communication from the city concerning changes in the code for rentals. You're saying you've had these laws for years, but it's been contested and lost before. I know you've altered them or changed them at the beginning of the year. That's fine. I'm not arguing any of that. I'm not the one trying to sue the city and change things. I'm trying to be in compliance. I'm trying to be a good neighbor. I'm trying to maintain property values. I've done all of that. I just don't feel I should be penalized when I've done all of that. I'm not the person you should be fighting with on this.
Where do we stand with the penalty? We have an unpaid civil penalty of $500. Is that correct?
That is correct.
What are you asking for?
I would like that to be removed. I don't think I should be fined for something that I don't feel I did something wrong at the time that my leases were enacted that were valid. I've been in compliance with everything else that I could possibly do before that. I asked that these people be grandfathered in because they were legally done prior to changes of the city code or amendments to the city code, whatever way you want to define it.
Is that a true statement, Officer Ramsey?
Is what a true statement. I'm sorry. There's never been an amendment to this. Really, there's been an interpretation change.
The only thing that happened in January, there was some definitions added to the code, but the use, guest house and transient quarters not being permitted in any residential district has been on the books since 1977, and prior to that it was on the books as a non-allowed use, as they called them, guest houses or tourist homes. It was a name change in 1977. 1986 it continued in that recodification, and since 1986, these are the other ordinances that have been adopted having to do with zoning, which I'm getting ready to go through, up until January of this year. So a lot of things happen in the zoning regulations, but this unpermitted use has been on the books way before the legislature acted in 2011. The only thing that happened in January was some addition of some definitions to help for clarification of and give more guidance to the enforcement arm of the city.
But may I interject? But none of that guidance was given to homeowners or people that were renting. And you've had rentals in Vero Beach for
I'm sorry,
decades.
but ordinances are advertised as required by law. If you don't want to come in and speak to your council about what laws they're adopting, I can't help you then.
Mr. Officer Ramsey, I noticed on the citation it says repeat violation. Am I missing something here?
And that's my other question.
It's on there, but there's not a check by it, right?
Right.
No, the repeat violation was checked off, I believe.
No.
Oh, you know what? There is no check mark, and there actually is no square as far as at least the copy goes. So.
It just says repeat violation. Or something
So it's not a repeat violation.
Correct.
Okay.
Now, did you say that the homeowners association was the one that called you?
Initially, it was my investigation of short-term rental websites. Ultimately, I've been getting calls from the homeowner association, representative, two different people, complaining about short-term rentals, not just his property in his
There's
defense.
4 or 5 in our neighborhood.
There's several in his neighborhood.
Complaining about it based on that they do not have anything on the books, or that's what's prompting the meeting to change it?
Well, just the fact that they don't like having neighbors that are doing it.
I've received no communication from my homeowners concerning anything, any issues with my property over the course of the entire year. The only communication I've had about rentals on my property have been from Mr. Ramsey twice.
Does anyone else on the board have any questions and like to move this along? If we could.
Can I clarify? Is that citation issued as a repeat violation?
It's not.
No.
That's my mistake. The words
So
repeat violation are on the citation, but the box next to it, it's not checked, so that would indicate that it's not.
I was under the assumption that if there was a violation, that the fines would begin after a repeat violation was found. Is that incorrect?
No, there are fines that are due on the first violation. Mr. McGann, did you have a question a moment ago for Mr. Clement?
Is it possible to try and negotiate this by reducing the amount of the penalty to $250?
That's within the board's authority.
All right, I make a motion that we reduce the penalty to $250.
Do you find that there's been a violation?
Yes?
Any other motions? A second of that motion even? Do I have a second? No second.
Motion dies for lack of a second.
It does.
I'll make a motion to find in violation also and recommend the penalties noted by staff.
I'll second that motion. All in favor?
Aye.
All opposed? Hearing none, motion carries. Mr. McNamee, thank you very much for your time.
And what is the appeal process for this?
Mr. Wayne, Mr. Commit?
It'll have it on the board's order. You have 30 days from the date of the order to appeal to the circuit court.
Okay. All right. Thank you. I don't agree, but
Thank you, sir. And thank you, Mr. Kesnick. Okay.
Thank you.
Yes, sir. Moving on to case number 15-CE-5838, Jerry Fulcini. You may. Yes, ma'am. May approach the podium. Ms. Fulcini, have you been sworn in?
Yes.
Okay. Would you state your name and address for the record, please?
I don't want to tell you my address. Karen Fulcini, 1015 Admirals Walk, Castaway Cove, Vero Beach, Florida.
One of the troublemakers.
Thank you. Staff.
Mr. Chairman, this is a case involving that citation. One second here. Citation number 1803 for Jerry Fulcini on Tuesday, June 23rd, 2015, approximately 2:34 p.m. I was driving through the neighborhood south of the subject property. I approached the property at 2500 13th Avenue, and there seems to be a slight discrepancy on the location, the address there. According to the property appraiser's office, we still have not worked out, but it's either one of two locations, and both of them are listed on the citation, 2500 13th Avenue or 1260 13th Avenue. I think it may have been annexed or zoned at one time differently, but I did note both of them on the citation. When I approached the property, I observed some construction activity going on there. I went up and spoke with an individual who said he had just sold the property and that he was on pulling his stuff out and loading him into a trailer. I did confirm that. I went around and took some photos of some interior demolition work, front door being installed, stucco being put on the fascia, and a little bit of construction work that was being done there. When I spoke with the individual who had sold the property, he said he sold it to Mr. Fulcini, and that the gentlemen that were there currently were working for him. One of them in a blue SUV was a electrician. When I went to approach these gentlemen, one got in his car and drove off. The other gentleman said he was just in there walking around, wasn't doing any work. And when I went back to my truck, he left the scene, and I have not seen or heard from him since. So I issued Mr. Fulcini a citation, number 1803, for $500 for unlicensed contracting under Ordinance 22-86A, and $500 for failure to apply for a permit under 22-106. They are currently working with the city and with a contractor to get that permit through the building department. Mr. Fulcini is here today, and Mrs. Fulcini appealing that citation. Their contractor is going to be Mr. Lewis of Lewis Construction, I believe. That's still the same. Mm-hmm. So as of today, the permit has not been pulled, but the process is in play for getting that permit. And in my photos here, you can see the front door of the property. The upper right photograph is the structure of the property, and it's L-shaped, which is the lower left corner of the picture. You can see the stucco that was put up in here. Demolition work underway, and the front door installed on that structure as well. And these photos were taken on June 23rd.
Is it a commercial building?
I believe it is, yes.
Ms. Fulcini?
Yeah, we purchased the building on 6/15. We purchased the property sits across the street from a mobile home park environment, and in that vestibule area and the front doors that were originally there was a lot of illegal activity going on in there with drugs and things like that. So on the 17th of June, like the next day after we closed, we went to Home Depot and bought some just temporary doors, and we did put in the doors just to secure the building because there was some drugs and prostitution things going on in that environment. So we did purchase doors from Home Depot, and we put in a wooden ramp just so that we could start wheeling stuff from the inside of the building, from the owner. We let the owner stay there, the guy that we bought it from, for 3 months to clean it out because he had been in there for like 35 years. So yes, we did put the door in, but we ordered a door from Vero Millwork and paid for that. But those they had to be ordered and they couldn't be put in because they were impact doors so those were paid for. I have the receipt for that too, but we had to wait for those to come in. But to secure that front, we didn't get a permit. We did put them in just figuring to secure the building. So that being said, that was done by us. The picture that you see where everything's like kind of in the middle there, we didn't realize that we needed to get a permit to clean up because the building was sitting, that one area was sitting there with Vero data for a long time with all his computer stuff, so that's what he was moving out. There were panels on the ceiling that were falling, so we pulled the rest of them down, not realizing we were supposed to get a permit for cleanup. I guess we cleaned up what we thought we were supposed to until we thought we were going to have to start getting permits. That being said, we got the permits for the doors. Randy Mosby was hired also to do a legitimate ramp for when the building was going to have to be entered and stuff when we rented it to new tenants once we got the building cleaned up. We applied for the permits and everything through the city of Vero Beach. It's just that Mr. Kecke and what we thought was cleaning up were two different things. I didn't think we were going to have to go for a permit until we actually kind of secured the building and cleaned it up. As for the bottom picture with the stucco fascia, I have a picture of that from 1986. That was always there, but because there was the undercarriage, it was falling out, we secured that and stuccoed over the top of that. Once again, obviously not pulling permit, we were just trying to secure things up. Really, we had no malintent to not do things the right way because we did hire a contractor, we did hire Randy, and we did hire Vero Millwork, but nothing was ready to be installed and permitted. We were just trying to secure the building at that point because of what was going on in the neighborhood. We actually own the trailer park and Vero Beach Import Auto Service. That's all kind of connected there. So when the guys did see Dave, they ran to go get Jerry. Jerry showed up and saw Mr. Kecke there. So there was nothing done to be sneaky. We were just trying to secure the property, knowing what happens there and what was happening in there. So that being said, we've been talking, Mr. Kecke, his boss, the people from the county and the city, trying to get all of the permits needed to get this thing secured and taken care of so that we can finish it up. But what you're seeing with the stuff going on that bottom lower picture was us just trying to clean out 35 years of Vero data's old computers. We had dumpsters there and everything, and we gave him 3 months to try to do the cleanup. So, I don't know. I guess the fines that we got, I don't think we were doing unlicensed contracting. Failure to apply for a building permit. See, I don't know where it begins. I don't know where it begins.
Well, that's a good question.
I don't know where it begins and ends. I don't know where cleanup of your property starts and then it ends with.
That's what your contractor is supposed to tell you. They should have defined that for you.
Well, what had happened was we had just closed on the building, and then 3 days later, Mr. Kecke showed up, and at that point...
Mr. Kecke, I'd like to know from you, in your opinion, do you believe that was, stucco aside, do you believe that what was going on in the interior was cleanup only?
I could not fully confirm that, nor could I confirm about the contractors. The employees working. When I cited them for an unlicensed contractor, the gentleman that I had spoke to Ken Strigley, who was a former tenant, I believe, is the one who had said that they were working there. The gentleman in the blue truck was or the blue SUV was a electrician, and both of them left. Again, how much of that was there was before we got there, I don't know. I saw the work being done there, the equipment trailers in the parking lot. So as far as the unlicensed contracting, I'm going to admit it is a little loose. It's a little gray. I based it on those gentlemen leaving, but I did not actually see them working. So that's to be noted.
Okay, thank you.
You said you're going to let the gentleman stay there for 3 months, starting on June 23rd?
When we closed on the building, we told Ken that owned Vetrol, before we even purchased the building, we worked out a deal where he had so much stuff from 35 years in that building that he asked if he could have 3 months to stay and move everything out and get all the stuff that he wanted to save. The other stuff, he hired Reliable Septic to have their dumpsters there. So we were all using the dumpster to try to help him clean that stuff out, because he had to be out by August 1st so that we could go in and literally start revamping the building to get it ready for us to rent it. So, yes, the original owner, Ken, I can't remember his name now because I'm nervous. Ken Strigley, yeah. We worked that out with him before we even purchased the building from him. He lives in Tennessee, so he was going back and forth trying to clean 35 years of an absolute disaster out of that building. So,
I'm inclined on some of these to be lenient when it comes to construction work, but when you hire an electrician, that draws the line for me.
I didn't hire an electrician.
It said an electrician was in there.
But we were just trying to get estimates. The guy in the blue truck?
Yes.
Yeah. He's a guy that does a lot of work for us through Tim McCord. And so we're just trying to get a grip on. There were thousands of feet.
Why would he leave if you were trying to get
They came to get Jerry. They were very nervous. They were all very nervous because we knew that once we saw Dave there, that Jerry needed to be there, and we were only across the street.
The electrician knew that he was in trouble when the officer showed up, so he left.
No.
Yeah, he fled the scene so he wouldn't get caught.
He didn't flee this. That's really not.
He left.
He came to get Jerry. He came to the shop, which is across the street, to get Jerry. And then Jerry showed up, and Mr. Kecke was there. But that's not fair, because that's not what this is about. We own a lot of properties in town. And we've worked with Mr. Kecke for years on getting our trailer park up to code, unlike the one that's across the street from us. So that wasn't fair. But you can believe what you want to believe. That wasn't fair, though, because we don't do that kind of business. We own way too many businesses in town.
I'm going to go on that path, what you just said. I know you own a lot of businesses in town. I've never seen you here before. And while I can, I personally think that if Officer Kecke, who's been doing this a long time, says that there was unlicensed contracting going on, then I'm going to tend to go along with that statement. However, I'm not convinced that there was actual work being done at that point. Well, like you said, it's a little gray. We're not sure there was any kind of real contracting, anything more than cleanup going on. And I understand putting the doors in; it needs to be secured, okay, and things like that. I'm not sure, and I want to know at what point did you, in your mind, think that a permit might be necessary?
Well, when we were told that from the guy at Home Depot that these were not impact doors that could definitely be on a property like that.
Yeah, but I'm not concerned about doors, because if it were my building, I would have done the same thing. We need something in place now.
Because the whole
for the safety of everybody.
The whole place has to be redone on the inside, and when we bought that, we knew that.
I mean,
that's not what we do. We fix cars and we have a restaurant. We don't do.
You had to make a decision based on other safety, I think. Okay, so that aside, moving forward, at what point in your mind were you going to say, okay, now it's time to pull a permit? Because I want to know.
I would say probably on the 23rd.
To do what?
To install the doors, to have the ramp put in, and then be able to go in there and actually physically figure out how and what we're going to do to rent this property.
Okay, and so I hope everybody can see why I feel like the needing a permit at that time, I'm a little bit gray on that. I'm not convinced that was maybe an infraction.
But you subsequently applied for and received permits to do the work as soon as you were cited, did you not?
Yes, that's correct. That's correct.
I noticed in a picture, the lower right-hand corner, there's a ladder up there and there's bare wires sticking down. When you purchased it, was it the ceiling stripped out like that?
No,
You did that.
it was not. It was.
Who did
It was. I would say it was 3/4 of the way collapsed. We pulled the rest of the panels down and moved stuff out of the way and started throwing things in the dumpster. I would say to help to clean our building out and to help Mr. Scrigley get the stuff out, just to get
Didn't
it out.
occur to you that a permit might be required for that?
No. We thought it was just considered cleanup of the property.
Mr. Chairman, I believe she had some with her. I didn't know if she had any other witnesses.
Well, that's a good question. Mr. Fulcini, I see, is here. Did you have any more witnesses to these events, or are you just speaking?
No, it's just
Okay.
us.
Okay.
It's just us.
Does he want to testify?
I mean, you can ask him whatever you like. I mean,
Well, it's up to him.
Yeah, he doesn't have to. I mean, Mr. Fulcini, if you if you want to let her do the talking, that's fine.
what she says.
We just want to make sure you have any witnesses you want to put on.
No, it is what it is.
Does the board have any questions? Mr. Chet, you have any statements?
No, sir, I do not.
Okay. I'm going to present a motion, and that motion is that.
Now, remember, this type citation, you cannot reduce the amount of the penalty.
It's all or nothing, correct?
It's all or nothing for whatever violations you find were committed.
Okay, I'm not convinced that failure to apply for a building permit is something that is actually applicable in this situation, at least not to the extent that they needed, to the quote work that they were doing. I think it's a little too gray. I do believe that if Mr. Kecke said that there were unlicensed contractors there, or some unlicensed contracting work being done, I tend to believe him on that. And so what I'd like to make a motion for is to remove the second violation of failure to apply for a building permit and let the unlicensed contracting stand for a fine of $500.
But he said he never saw those unlicensed contractors doing any work.
Yeah, he said it was a gray area as well.
So,
well, my question, Mr. Kecke, is this commercial property such that you'd have to have be a general contractor of some type?
Yes. To my knowledge, you couldn't pull an owner-builder permit for something like this, correct? You'd have to have a licensed contractor who's qualified to do the scope of work.
Correct. And to put the doors in, it would require a permit, whether they came from Home Depot. And I understand it was a safety thing, but you can put up plywood and make it safe and, go.
Yeah, there was plywood put up on those doors originally, but we couldn't get in and out of the building, nor could Mr. Scribb. But I hear you.
Correct. And that does require a permit.
I didn't know that.
I'll second the motion.
all in favor?
Aye. Aye.
All opposed? Hearing none, motion carries. Thank you, sir. Thank you, Mrs. Fulton. So
one, but not the other.
you've got a $500 fine that needs to be paid, and any work moving forward needs to
Okay.
needs to be
Thanks, guys. I
permitted.
appreciate it.
Than't you for coming in.
Dave, everything. Appreciate it.
Place used to be a church back
I
in the
know
50s.
you're going to hear a lot from us, I'm sure.
I'm looking forward to seeing what you do with the property.
The cleanup thing keeps coming up, for us.
Okay, moving ahead. We're going to go to case number 15-CE-5681. This is for Irene Snyder.
Thank you,
Mike,
Ken.
Mr. You're going to stand at the podium.
Yes, sir. At
Thank you.
least to begin with, John Kesnick on behalf of the City of Vero Beach. I'd like to begin first with testimony from Ms. Sanderson, the code enforcement officer who handled this matter. Ms. Sanderson, isn't it true that you first became aware of this property and investigated it back in March of 2013?
Correct.
And during that investigation, did Ms. Snyder bring various leases to you?
Various leases were brought to the planning department and given to the director.
And those leases, they were for the current tenants of that property, is that correct?
Yes.
Okay. Can you see the exhibit that's up on the screen, Ms. Anderson?
Yes.
And is this one of the leases that you were provided?
Yes.
Does the lease, and where I'm pointing to, does it indicate whether a bedroom is offered for lease or whether the entire premises is offered?
It reflects the northeast bedroom as being the leased rental space.
So a single bedroom in contrast to the entire apartment?
Yes.
Okay. Is this another one of the leases that you were provided?
Yes.
And does that indicate a single bedroom that is for rent?
The northwest bedroom, yes.
Is this one of the leases you were provided?
Yes.
And which, does that indicate a single bedroom that's for rent?
The middle bedroom.
Okay. And is this also one of the leases you were provided?
Yes.
And does that indicate a specific room for rent?
The southeast.
So all in total, you provided 4 separate leases with 4 separate bedrooms for the premises?
Correct.
Did you do an inspection of the house during this first investigation?
I did.
And what did you find?
I found a common area of a kitchen and a living room and individual doors.
Melody, is your microphone on?
Yes.
Can you speak up a little bit then, please?
An inspection revealed a common area of a kitchen and like a living room, and then individual doors going into bedrooms, I assumed, with locks.
So each room had an individual lock that would prevent access to other people that live there?
Each room had a lock, correct.
Is it true that you next conducted a second investigation on this premises in November 18th of 2013?
Probably was an inspection by the outside, yes.
Okay. And were you aware of that at that time, an advertisement for a single room for rent and a quote-unquote private room at the premises?
Yes.
Did you issue a warning on November 20th of 2013 that advertising individual rooms was not permitted?
Yes.
Ms. Anderson, can you see the exhibit that I have on the overhead here?
Yes.
Can you identify that, please?
That is a copy of the warning citation.
Okay. And can you see the date on there?
November 2013.
Okay. So this is the one that we just spoke about?
Yes.
Okay. Ms. Anderson, the third investigation that you did on this property initiated July 1st of 2014. Is that correct?
Yes.
And is this in response to a letter from a neighbor indicating that there were still single renters in the using this establishment?
Correct.
Ms. Anderson, can you view the exhibit that I have placed on the screen?
Yes.
Can you identify it, please?
It's a copy of the complaint made by Mr. Catania.
And this complaint indicates that there are multiple individuals unrelated living in the premises. Is that correct?
Correct.
Ms. Sanderson, the fourth investigation that you conducted on this property began on April 24th of 2015, where you issued a warning for the same exact conduct. Is that correct?
Correct.
And my understanding is that you then amended that warning. Is that correct?
I did.
Okay. Ms. Sanderson, can you see the exhibit on the screen?
Yes.
Can you identify it, please?
It's a copy of the amended citation, the warning.
And what activity does this citation indicate that is against city ordinances?
A boarding house in a residential area.
And that would be a house that rents individual rooms to people?
Correct.
Okay. After this second warning, did you receive any response from Ms. Snyder, the owner of the premises?
There was no response to me for the amended citation, no.
Did you ultimately end up issuing a citation as a result of the conduct there?
A citation was issued, yes.
Ms. Anderson, can you identify the document that's on the screen now?
It's a copy of the citation that was issued.
Okay. What is this document here?
Certified return receipt that accompanied the citation that was returned to us showing service.
Who is it signed by?
Irene Schneider.
Is that the owner of the premises?
Yes, sir.
Ms. Snyder, can you see the document on the screen now?
Me?
Or Sanderson, I apologize. Can you view the document that's on the screen now?
Yes.
Can you identify it?
It's an advertisement for a room at the property.
And is that an individual room or for the entire premises?
It's for an individual room. If you look down to like paragraph 4, this room is available.
Right where my finger is?
Correct.
Okay.
Yeah, what's the date on that document?
The date, this would have been during, I believe, your second investigation in 2013. Is that correct?
Correct.
Ms. Sanderson, do you recognize the document that's currently being displayed?
It's a copy of an affidavit that was given to us by the neighbor, Frank Catania.
Okay. And this precipitated the fourth investigation and ultimate citation to the property?
Correct.
Paragraph 8 indicates that there is two females and an unknown male living at the residence. Is that correct?
Correct.
I believe the top sentence of the second page of the affidavit indicates that they use separate entrances to the property. Is that correct?
Correct.
Ms. Sanderson, as part of your investigation, did you take photographs of the residence?
I did.
And did you take photographs of multiple different vehicles titled to different people that live at the residence?
I did.
Is this a photograph, one of the photographs that we just spoke about?
It is.
And this displays two separate vehicles, a Pontiac and a Volkswagen, is that correct?
Correct.
And this is a separate vehicle, a Ford truck that was located at the residence, is that correct?
Correct.
This photograph displays two Volkswagens, again, one of which is the same vehicle, but a second one which is actually a separate vehicle as indicated by the different license plates. Is that correct?
Correct.
Is this a registration for one of the vehicles?
Correct.
And this is a separate registration for a different individual. Is that correct?
Correct.
Using that as their home address? Is that what that registration said? 655 Banyan?
Yes, ma'am. One registration lists that. The other one lists a P.O. box. Are these photographs that you also took, Miss Anderson?
Yes.
And we have a Pontiac that we previously saw and then a separate Chevy vehicle. Is that correct?
Yes.
So, Ms. Anderson, briefly summarizing your investigation, you had 4 separate investigations over a 2-year period, photographic evidence, an actual in-home inspection. You were provided leases that indicate that all of the renters are renting in single rooms as opposed to the entire premises, and multiple different people living there. Is that correct?
Correct.
I have no further questions at this time. Thank you.
Thank you. Mr. Siegel, you're representing the violator?
Yes, Barry Siegel, Office of Barry G. Siegel, PA, 3096 Cardinal Drive, Suite 2C, Vero Beach, Florida, 32963. And I do have Ms. Snyder here with me, but at this time, until necessary, I'll speak on her behalf.
Sure.
Frankly, if I just to keep the continuity, if I could address a couple questions of Ms. Anderson before I speak, that might
absolutely
keep things while things are fresh in their minds. Ms. Sanderson, as a code enforcement officer, can you tell me, is it the policy of the City of Vero Beach that only related individuals may reside in a home together?
I don't know. I think that it's just that you can't rent individual rooms.
My question to you is it the policy of the City of Vero Beach? If you don't know, it's
I don't
okay.
know.
Okay. And so then let me ask you the question. The testimony that you've given today that's indicated that some of these individuals are unrelated, how is that relevant to your finding of a violation?
I don't know what you're asking me.
You've testified that the individuals were unrelated. Was that important? Is that relevant to any of the issues before the board today?
No.
I agree with you. I just don't understand why that's
I
even...
testified to that by identifying the pictures.
Okay. Well, let's talk about the pictures. You took pictures of cars, correct?
Correct.
Okay. How are the cars relevant to your finding of a violation today?
That it was different occupants.
Okay.
Just verifying that those cars went to the occupants.
Is it a violation of the law to have different vehicles?
No.
Okay. Was there a parking violation that she's been cited for?
No.
Okay. Does it matter in this case if those cars belong to one person or 4 different people?
I don't believe so.
Okay. So how was that testimony relevant to the issue that's before us today? I'm just trying to clear up the issues that I need to respond to, and I really didn't, frankly, expect to even see that. And so I'm just I'm trying to understand why that's even relevant to what we heard about.
I guess just because when we go, we document what's there. So that's the documentation of the vehicles that were at the property.
Okay. Thank you. Now, were you present at the meeting? Well, let me take a step back. Are you aware of how long my client, Ms. Snyder, has rented out this home to individuals? Are you aware? Let me ask you. Are you aware that it's been about 20 years that she's been renting out this home?
Yes.
Okay. And your first cause to concern with this property is when the neighbor moved in, Mr. Catania, and started contacting you?
Correct.
Okay. And there's been no violations or issues with the property before that, correct?
No.
Okay. And then do you recall a few years ago when the city changed the boarding house definition and changed the code regarding boarding houses?
There was some changes in the code, yes.
Now, were you present at the meeting when the planning director, Mr. McGarry, informed Ms. Snyder that in order for her to maintain in compliance, that she needed individual leases from these people?
I believe in that meeting he said that she would be better to have one lease to one individual.
Okay. And prior to that time, are you aware of what her leasing situation was?
No.
Okay. Now, you conducted one in-home investigation, correct?
Correct.
Okay. Now, let's say I was renting that home, just myself, individually. I'm the only occupant. How would the home have looked different to you with one occupant as opposed to Ms. Snyder's current situation?
That the doors necessarily wouldn't be locked going to the bedrooms.
Okay. But they could be locked?
They could be locked.
Okay. Is a lock on a bedroom door, is that something uncommon that in your practice?
Not a handle lock is not uncommon, probably, but a lock, yes.
Melody,
Okay.
please speak into the microphone.
I am.
Thank you. We can't hear you.
Okay. So other than that, the home looked the same as it would for any other home that you've visited?
Yes.
Okay. At this point, I have no other questions for the witness. Just would like to offer some testimony on behalf of Ms. Snyder.
Okay.
And I do have, and Ms. Snyder is here, and she is prepared to testify if necessary. This is not her favorite place in the world to be. No disrespect intended to
Understand that.
be very good volunteers of the board. But I do have an affidavit from Ms. Snyder that speaks to a couple of different issues. She is the owner of the home, of course. There's no dispute of that. She allows possession of that home pursuant to a verbal lease with all of the current tenants of the property. She has always maintained a practice of she just rents out the house to individuals as a lease, one lease to all these individuals. There's never been an issue until there was a change in the recent years that precipitated her to have a meeting with Tim McGarry, the planning director, where I'm not going to sit and guarantee you that exactly what he said, but I can tell you what my client heard. It's in the affidavit, and she will tell you, is that he said, Irene, in order to be in compliance, you need individual leases from all of these people. I've spoken to Mr. McGarry myself, and I think whether what he meant to say or what he said and what she didn't hear is you need to have a lease for the house for everybody to be a party to, and then there's no issue here. I think that my client may have misinterpreted that, but shortly after or immediately after that meeting, she went and said to her tenants, here, you guys now need to have individual leases. I can't rent out the entire house to all of you. You need to have these leases. That's why those leases were there. As soon as I contacted her with the new flurry of violation notices and citations, they had a lease burning party. Like, we don't need these. We don't want these. We all lease the property together. There is no difference in that situation than if four buddies are enrolled at Flight Safety and they want a house to live, and they contact Ms. Snyder and say, hey, we want to rent your house. They may be strangers to each other. Flight Safety may have put them together. They may be the best of buddies returning to get their instructor certificate. But it's the same situation when you've got four roommates leasing the house together, and that's all that Ms. Snyder has here. Is she's got these four individuals leasing the house together, and that's what her affidavit says, and that's always been the practice. I know that there may be some skepticism, like, well, you've kind of got strangers here versus people that come to you, and that's really not the case. She's been doing this for 20 years. The average person stays approximately 2 years. This is not an fly-by-night, overnight operation. These are people that come together, live, and they become collegial and they become familial. And Mr. Clement will tell you that the city of Vero Beach, one of the biggest reasons that they had to change the code a couple years back is it discriminated in violation of federal law, saying you had to be, the definition of a family unit had to be related. There is no obligation. These people have to be related. These people are coming together, they lease the house, they divvy up whichever room they designate as their own room, but they all have access to the entire home. There's one kitchen, there's one living room, there's one dining room. They are allowed to park their cars. There's no violation as a result of what they're doing with that. They, most importantly, no longer have these individual leases, which she only put in place because she thought she had done so to placate the city of Vero Beach. And bear in mind, those were in place for a year or 2 years before someone came knocking again saying, oh, you've got a violation here. Everything she's doing is completely above board. The image that I get in my head is maybe because she puts the people together as opposed to the individuals coming to her, that there's a difference. Under the law, there is no difference. Your code provides for you. She can't rent out individual parts of the house or restrict or limit parts of the house. She does not do that. They have a master lease that they have together, and they do as roommates would do, as you would do. Think back to your college days. They all pick a room, choose it, respect it, and she's never had an issue. And the only thing I could think of, as I'm sitting here, is when people are dating. Would you say a couple that met on Match.com and got married is any different than friends that got married, that met the traditional way, got introduced, or a setup, or met at work? This is a very normal situation in this property, with all of them living together under one roof, under one lease for the entire home, simply stated, and nothing more than that. Under the language of the violation notice, under the language of the code, you do not have evidence before you to find that she is renting out individual parts of the house. I have her affidavit. If need be, I will have her come up and tell you the same things that are in her affidavit, that they all rent the home jointly. Thank you.
I want to extend the meeting. That's not necessary. Ms. Shell?
Yes, I want to know, she's been doing this for 20 years. Has she paid any tourist taxes at all?
There's everybody there is long term.
Mr. Kesnick?
For clarification, I think what Mr. Siegel is saying is there is no tourist tax, no bed tax that's paid. However, typically in a lease, you would be, and actually I'm not sure on a residential, Mr. Siegel, you may not even have to collect sales tax. I'm not sure on that.
No sales tax on residential.
Yeah.
Go ahead, Mr. Cousin.
Thank you. I guess just to kind of bring it back to, and as I know everybody on the board knows we're here, but just for my own train of thought, this is a fact-finding board, and what you have here in front of you is a conflict in the evidence. Any judge or jury, depending on the circumstance, that would be what your job would be. What are the actual facts? I've been presenting two different sides of the story. And the evidence that we've presented here is we have multiple leases that have been designated specific rooms. We have special types of locks, as Ms. Anderson described, not a normal lock that you would see in a normal residential house, that make those rooms isolated from one another, as obviously if you're living with a stranger, you don't want to have access to your room. If you're only renting an individual room, you wouldn't have access to their room. Additionally, we have photographic evidence of unrelated people that live at the house sometimes, and different people throughout this time period. And that's what is important about the fact that there's unrelated people, because what makes sense in the context of the evidence, are these individual facts possibly damning? Maybe not. But when you look at the picture altogether, all of the facts together, it's disingenuous to say that these people have a group lease with a bunch of strangers that might be there for 6 months, might be there gone. So this person comes in 6 months, you don't know this person. He has access to your room because it's a verbal lease, and he has access to all the rooms in the house. I think that type of argument is disingenuous because it doesn't fit within the facts, and that's the facts that you've actually been presented. Furthermore, to say that it's a verbal lease that have all these conditions on it, it's a verbal lease. It's not written down anywhere. So where are these conditions? Do they change? It's just not the nature of verbal leases. That's why people make leases. So there are written boundaries written conditions, it's been clear, and we've demonstrated through photographic and documentary evidence, a pattern of multiple years of renting these individual rooms. And I will point out, outside of the leases, which, again, you have a conflict in the evidence that Mr. McGeary might have told her to bring leases this way, but then we have the testimony of Ms. Sanderson that contradicts that, saying that, in fact, he told her to bring in one lease to one person, which would be possibly within the statute. Certainly the individual leases would not, so it wouldn't make sense for Mr. McGeary to advise her to do something that violates the code. Furthermore, though, looking at the individual leases, that's backed up, and it's in the evidence by the advertisement that advertises an individual room. Mr. McGeary didn't tell her to put an individual room up for rent, and that was in fact cited. She was cited twice, warned about this behavior, and still it continued on top of the observations of neighbors, the affidavit of a neighbor, and the photographic evidence. So I just wanted to kind of summarize that and put it into context. Thank you.
Thank you. Ms. Siegel?
If I may respond just briefly to that. The evidence that you saw, the pictures of the car, is completely irrelevant. Has no relevance here. You are required to look at your code provisions. Your code provisions do not speak to locks. If it's going to be the position of the Code Enforcement Board that you are going to prohibit people from putting locks on their doors in their homes, that's going to be a whole different story. You're also not allowed to look at, or even consider, in my opinion, the relationships between these parties. That is a gross violation of federal law if the city is going to take the position that you are now only going to allow rentals of related people. I think if you even consider that evidence for a moment, you create a great problem and concern. And so I want you to just remember what the law is here. I mean, as you stand here, the leases, and my client is put it on her affidavit, and I'll get her to tell you if you want to hear it straight from her. They've burned the leases. Those individual leases were only in existence to placate the city of Vero Beach, and after our discussion, they've been burned. They do not exist. There are no individual leases here. There is no differentiation in the code that requires you to have a written lease or a verbal lease. You have no evidence of a violation before you as we sit here today, based on what my client has affirmed in her affidavit.
Okay.
Mr. Chairman, if I may, it may be helpful. I can read you the definition of a boarding house.
I want to know a few things, and yes, sir, that would be helpful. But yes, sir.
Shall I go ahead? Okay. Boarding house is defined in Section 60 definitions appendix as a dwelling unit within which more than one individual room or one suite, but less than the entire dwelling unit, is used, maintained, or offered for rental.
So,
in other words, one room is permissible, but more than that, it becomes a boarding house.
I could be wrong, and I know that there is a criteria involved here. Let me start with this question. If there were no lease at all, would they be in any violation? It's hypothetical, but
there would if someone is staying on your property and you're getting money for that, there is some form of lease or rental arrangement, because leases are not only written; they can be verbal or oral. But there is, if someone's getting paid for the use of the property, there's some kind of arrangement.
Okay.
And the definition talks in the verbiage of rental.
Okay. And I realize that our job is to interpret whether there's been a violation of code, or i.e. the law. But if my memory serves me correctly, we've had situations in the past where 4 people or less were communing in a house together, unrelated, and there was nothing that could be done with regard to a violation.
Well, and Mr. Siegel is absolutely correct. The city did specifically change the definition of boarding house because it did used to rely on familial, that is, living as a family, and that isn't proper in today's day and age. The courts have said that you can't base who can live together based on whether they're related by blood or marriage. So you get away from the family language and that's why the code was amended to talk more in terms of what is actually happening on the property. If you're renting out individual rooms, you have a boarding house. If you're not renting out more than one separate room, which was, and I can't speak for Mr. McGarry, he's the author generally on the land use regulations, but the example was the retired couple that has an extra bedroom. In theory, they could rent it out without violating the boarding house regulation.
So based on code today, based on the ordinances in place today, by having a single lease or multiple leases, because there is more than one room that's being occupied by unrelated individuals, there is a violation. That goes without standing.
Being unrelated has nothing to do with it. That has nothing to do with it. Whether they're related or not. It's whether or not the rooms are being separately rented out to separate people.
So if these separate people, I'm just trying to be clear here, because it seems to me there was one lease at one time and there was a misunderstanding, a misinterpretation of what needed to be done, whether that's disingenuous or not. And what I'm trying to get here is, if indeed there is or was one lease, does that fall under what we will accept as no violation? Am I clear?
Well, in theory, a rental arrangement of some kind, written lease or an oral rental arrangement, could be entered into by multiple people with the landlord. And if there's one arrangement, then in theory there's one lease. And again, as Mr. Siegel was pointing out, is it the entire home being rented out, or are they being rented one room and given access to the rest of the house?
Okay. Mr. Siegel, could I ask you a question?
And you probably should hear from John also.
Sure. But my question is, currently, is there one lease or multiple leases?
It's one lease for all of them.
Okay.
It's a verbal lease, according to this.
Absolutely. It's an oral lease, yes.
Mr. Kesnick?
My position is that the evidence doesn't support that contention. I understand she's saying that and she's given an affidavit, but I think in view of the total circumstances with different people in and out of the house, and the fact that you've actually seen written individual leases for individual rooms, I don't believe that affidavit is accurate. So I believe that there are separate leases. Even if they are verbal, it's separate verbal agreements per room.
Siegel, do you happen to have a copy of that lease agreement, the one that's in place today?
It's just an oral. I think at this time, maybe if it's not going to be out of order, I can have Ms. Snyder join me at the podium, and she can explain to you. But I mean, there is no written lease. It's just the parties agree. They write checks for the rent, and they get to use the house, and they divvy up, who stays in which room amongst themselves.
So are they all under the same dates? The lease starts now, the lease ends?
Well, because we've had to have the collective lease burning, yes. It all started fresh, and it had always been like that before. Before they had to make the change back in 2012.
So the 4 people that are living there now, their lease ends when?
It doesn't. It's just a perpetual lease.
Perpetual verbal lease or a?
Well, I mean, under the law, you can have a 1-year lease without being in writing. But this is all relatively recent. I mean, I will tell you that under the law, my opinion is it does not matter if it's written or it's oral. If what this board wants to hear is that there is a written lease and that's what's required to bring it into compliance, that's not an issue. My client and the tenants are happy to do that. For the purposes of what you have before you, there is no differentiation between a written and oral lease. If it goes to the credibility issue, then maybe you need to hear it from Ms. Snyder directly, that this is how they do it, as opposed to just having her affidavit in front of you.
Mr. Chairman, if I may. Mr. Siegel, when is rent paid? Is it paid
monthly?
Monthly? Mm-hmm. So basically you're saying what they have is a month-to-month tenancy.
It's probably more like a year lease, because again, if we had a month-to-month, then we would have a tourist tax issue.
Right.
And so it is a year-to-year lease. Or it is as of now. Yeah.
I'm having problems with this one because I'm really personally, and I'm supposed to be unbiased, but personally I'm against this communal living thing altogether. But at the same time, personally, I'm not seeing that there's sufficient evidence there's been a violation, except for the advertising of rooms for, what was it, a week or something like that.
I don't think it was for the week, but that advertisement starts with home to share.
I thought I wrote it down. I thought that there was a advertisement out there for this
John,
property.
do you have
There is an advertisement for an individual room for rent.
And I believe that was in 2012.
13.
13, excuse me. So that was about two and a half years ago.
And we have no indication that arrangement's ever stopped, and now we have burning of leases. So.
Is there advertisement out there now?
There is an advertisement out there now that talks about home to share.
Even though you have your 4 rooms rented.
I think one person may be moving on. She's been there about 2 years, and so she may be moving on. So it may be an assignment. There probably will end up being an assignment of the lease on that situation. If you find that there is a violation here, then you are going to make it impossible for the good old days with the Dodger Town, when the Dodger minor leaguers would come and rent a house together. When you have flight safety students that come here and want to rent a house, you are going to make that illegal.
As long as it's longer than 30 days. Not
Well, that's a
short-term
whole
rental.
different story. The baseball players certainly wanted to be here longer than 30 days, and the flight safety students the same.
Yeah, I see it. I do. I mean, I do see where you're coming from, but there also has to be. In this, again, I'm probably going on a tangent. There also has to be a limit on. I mean, how many people can do this sort of thing? If you've got a 4-bedroom house and 8 people living in it, that can't.
Well, not to interrupt you, Mr. Howell, you still have the code that speaks to how many occupants you may have in a home. I mean, that's one, that's not the violation that's before you, but 2, you have a totally separate set of code provisions that address the volume in a home. You have everything from parking and the limitations to occupants. So that is addressed.
Mr. Kesnick, would you mind refreshing my memory on what violations there are here? Are there multiple, or are we on just one?
It's a violation of the zoning ordinance that you can't use this for a commercial property, and the commercial activity here is that it's a boarding house, that the individual rooms are being rented. So that would be the violation, is that it's being used for a commercial purpose that's specifically outlined in the city ordinances that it can't be used as. And that purpose would be a boarding house, again, the individual rooms being rented to people on an individual basis that were advertised and that the individual leases we had showed.
Thank you. I'd like to hear from any member of the board.
And so what are the fines to this point, at this point?
At this point, it's just an initial violation. There were 2 warnings. This is just but there's only been 1 citation. It would be a $500 fine.
So a $500 fine for this, does that mean she has to stop with her?
The board would then need to set a date for her to correct the activity.
Yeah, exactly. If the board was to find a violation, you could, or it's in the board's discretion whether or not you impose the initial penalty, and you would. The order would typically issue that says that the activity is to stop by a certain date.
And then what happens if the activity's found? If they find that it's still going on, she's going to be before us again. She can be with a repeat violation, and essentially what will happen is that house will not be rented in the way that it is any longer.
Yeah, for 2 years.
It would have to be a more, I don't know, traditional lease if it were to still be leased by possibly a family or an individual. But I'm an opinionated person, and usually I have one, but I'm a little stumped on this one, quite frankly. And I want to move this along, and I want to present a motion, but I'm really stumped at the moment, and I'm asking if anyone else has a motion, perhaps to
I don't think it's a problem at all. I think she's clearly in violation. I'd make a motion to find in violation.
Do I have a second?
I'll sign it.
All in favor?
Aye.
All opposed? Me.
Nay.
One opposed.
Okay. This is going to be tough.
Passes 3-1.
Actually, I'm opposed.
Well, then it
Okay.
fails.
It's 2-2.
It's 2-2.
So it fails.
It's 2-2. It fails.
It's 2-2 because I'm still not. I'm not. If we set a precedent here, Mr. Siegel's correct. If we set a precedent here, it could have.
But I'd like to ask Mr. Siegel a question. In the documents that we were provided backing up this citation, there's copies of correspondence in June between you and Mr. McGarry of our planning department talking about trying to get this residence vested because of the long time operation as a boarding house, grandfathered in to continue in that manner. And in this correspondence, if you'll permit me, explain my confusion. It says Mr. Snyder was well aware the city still considered she was operating a boarding house both before and subsequent to enactment of the ordinance amending the definition of boarding house. She had been told by the planning director that she could easily resolve this problem by entering into one lease agreement with one or more individuals for the entire single-family residential residence rather than entering into separate leases with each individual for a specific bedroom suite with access to common living kitchen and laundry facilities. And he says she ignored this advice. Therefore, it is my opinion that her property is not eligible for vesting from the new provision of the amended regulations. Now, that's in contrast to the affidavit provided by Mrs. Snyder, which says that Mr. McGarry informed her that in order to be in compliance with applicable provisions of code, I was required to have individual leases with each of the individuals for less than the entire dwelling.
Yeah.
So what's going on
And
here?
that's what I said when I spoke is I think that, and when I initially presented that, I had said I think that she may have misunderstood Mr. McGarry, that he was telling her she needed one lease for everyone, and I think she heard, because why else would she have even gone through the efforts to then go and find and create these other leases? But what you need to look at now is those leases are gone. This violation does, I think you would look at that situation and say, well, that was done innocently or was done as a result of mistake or misunderstanding. She's not a professional landlord. She's not a management company. It was just it was a mistake that she had made. But what you have before you is that has been corrected, that they literally had their lease burning party and they went back to just one lease the way it always has been. And so you're right that I would tend to believe that Mr. McGarry did say one lease for everyone, as she has now, and just misunderstood that when he had told her that.
Well, he even gave her more of a room to swing here by saying into one lease agreement with one or more individuals.
Right, and that's what she has now.
But this is a verbal lease, you say?
Yes. Like I said, if the board is going to take the position that it mandates written leases for this situation, which I think is bad precedent, but that's easily accomplished. That's not a problem. But there is no differentiation in your code that would require a written lease over an oral lease. That is not found anywhere in your code that you've sworn to enforce.
This discussion is irrelevant. The decision's already been made. The vote's been taken. Let's move on.
Just for my purpose, what was the vote? Was it 2-2?
It was 2-2.
Well, that motion failed, but that
we'd have to put another motion on the floor in order for.
Well, if you let it stand as is, basically there would be. It kind of leaves it up in the air.
Right. So where do you go from there? I mean,
the motion.
It in code.
But the motion was to find there was violation. If that was my correct recollection.
Yeah.
If, in fact, you consider that the motion failed, the opposite would hold true, that then there was a finding of no violation, unless you take another vote.
You're saying that if we say that it passes on 2 nays and 2 yays, that, in fact, what we're doing is we're finding there's a violation.
Finding there was not a violation.
Just the opposite.
Just the opposite.
If I could offer one solution that may allow the board to have their cake and eat it too, if they were to stay this for 1 month, my client will submit written lease to Mr. McGarry or Ms. Sanderson in the interim, and you don't have to make a ruling on this particular violation. It can go away. You don't have to worry about the precedent that you set for all of the other individuals, and everybody goes on being happy.
I mean, and this is part of, and I understand that there's nowhere written in the code that it has to be written. Okay, it could be oral as far as we're concerned because it's not stated anywhere. But we've been presented with evidence that there are individual leases and not with evidence that there's an individual lease.
Well, you do have the affidavit, and if you want to ask Ms. Snyder, she'll tell you right now.
I don't know.
And Mr. Siegel is right. There is no legal requirement for a lease to be in writing unless it's over a year. And then that's a state law says you.
Over a year.
Well,
they said they were over a year. That's why they're not paying taxes.
It's year to year.
Right.
Yeah.
This is one of the hardest ones.
Come on, let's move on.
We do need to move on.
The vote's been taken. Come on.
Your motion was to
find in violation.
Please,
okay.
Please don't.
And I have a second, right?
Mm-hmm.
And I want to ask again.
So with 2 and 2, it's nothing then, right?
Please.
If it's
These are wonderful people.
2 and 2. Perfect. I want to be clear. We've got 2 yays, 2 nays.
The motion fails, and unless you take further action, it would be interpreted as the opposite would hold true. There was no finding of a violation.
As it stands, the vote says she's not in violation.
Right.
Thank you.
Mr. McGann, do you still stand on?
I'd like to make another motion that we stay this, as the counselor suggested, for 30 days. I think that would give her an opportunity to come up with a written lease and give us an opportunity to further research the situation.
I mean, if she wants to submit that, that would be additional evidence to show to you. Now, remember, the citation goes back to
2015.
Yeah.
Actually, it says that there was a violation on April 24th, 2015. So really what you're concerned with is what was happening on that day. That's the date she's cited for.
Well, that's true.
Remember, too, there'll be more than 4 of us here for this bid, and there'll be a definitive vote if she takes it.
I mean, you can ask for, if she wants to voluntarily bring you back a written lease, fine, but there's no legal obligation for her to do that.
If she did bring back a written lease, would it change this scenario that we're talking about? I don't think it would. I don't think it would. And if we're speaking specifically to the violation that for the citation on that day, where we have evidence of multiple leases, am I right?
No, those go back to 2012.
Oh, they do?
Right.
Oh, you guys are killing me here.
And then the advertisement was 2013, unfortunately.
I don't think that presenting a written lease is going to change anything because, as it was stated, there's nothing in the code that says. And then if she takes
what happens if an enforcement officer goes back next week? She's still in violation?
Well,
she'll be cited again?
As I understand,
no, by the vote we've taken, she is not in violation. She won't be exposed to that again.
She'll be fine, but not exposed to that.
Not as a repeat.
If she was, if the council or the board is finding that she factually actually has one lease, then she would not be in violation. But if their code enforcement officers were to go back, and in fact these people have individual leases for individual rooms, even if that's a verbal agreement, they don't have access to each other's rooms, then that would be a boarding house if it's more than one room, and she would be in violation, could be cited again, and would be.
Okay. Well, I think in that case, I'd like to change my statement. I'd like to vote yay on
Well,
the motion.
okay.
Well, we need a new
Well,
motion.
Mr. McGann, you made a motion to put it and stay, then that was not seconded.
I'm sorry. You did
Correct.
make a motion.
Failed for lack of a second.
Right, it failed for lack of a second.
Right, so now we need a new
you need a new motion if you want a motion.
I'll make a motion. She's in violation.
I'll second that motion. All in favor?
Aye.
All opposed?
Nay.
Hearing only one, motion carries.
So that was 3-1.
That's 3-1.
Motion passes.
Okay,
Now,
thank you.
you'll need to also set a date for compliance and whether or not you're imposing the initial $500.
The ordinance says it should be at least 30 days. That'd be the maximum.
I agree. At least 30 days.
Make a motion to give her 30 days to correct a violation. And I don't think she needs to pay the $500. So I don't see a fine.
I don't either.
Well, you can withhold that until after the 30 days, and once you get your compliance report, if it's reported she's in compliance, you
Good
could
idea.
waive the penalty at that time.
Let's
Let's waive that until the 30-day correction. If she's in correction, if she's not, then the fine will be imposed.
I'll second that. All in favor?
Aye.
All opposed? Hearing none, motion carries.
Thank you very much.
Thank you for your time, and thank you, Ms. Snyder. Thank you.
That's all that I have. Thank you for your time.
Okay. We've been in here a little over an hour and a half at this point. If I could just ask that we have a quick 5-minute recess starting now. Thanks.